Hey guys, Tammy here. And in this video, I'm going to talk about, can you bring evidence to court? All right. I get asked this sometimes, like, oh, can I bring this picture? Can I bring this text message? Can I bring whatever into court and show the judge? And the answer to that is, yeah, of course, you can bring anything that you want to bring that you think is helpful to your case. The problem is, in most cases, you cannot just walk in the day of and pull it out of your hip pocket and be like, ha ha. Now I know we all watch the legal shows on TV where that kind of stuff happens, but that is not really procedurally allowed. Okay. So, and the problem is it's different in every jurisdiction. So I'm going to give you kind of a high level view of how this works. And I'm going to tell you where you can dig in to find more information to figure it out for, your state and county specifically. Before I do that, let me just remind you, if you like this content, you find it helpful, don't forget to hit like on this video and also subscribe to the channel, particularly if you're one of the 70% of people who are not subscribed. You need to go over and do that. Also, please, as always, feel free to share this on social media. Such a tough thing when you're going through this as a parent, and you're trying to help your child and you're trying to help yourself and do all the things that you have to do. It's a real struggle. And I know a lot of people are looking for help with these kinds of issues. So when we go into court, one of the things that happens is in family law, everything has to be submitted in advance, okay, of the hearing. And you have to send the other side copies of it and you have to file it with the court and all of those things. And everybody has to know what we're going to talk about, what's going to be presented on that day. Because if you just show up with some random thing, then the other side's like, well, I don't know where that came from. I haven't had a chance to look at it. I haven't had a chance to give a response to it. Nothing. And a lot of times what will happen is the court will say, okay, well, then we can either disregard it or we can reschedule you. All these different things that can sometimes come out of it. And I think that particularly whether you have an attorney or not, if you're self-represented, obviously people don't know these things and timelines and all that. And then even if you have an attorney, it's still important that you know all the timelines and everything, because if you don't have everything to your attorney in advance of whatever their filing deadline is, it's not going to make it into the court's file and you're not going to be able to talk about it. So I'm going to kind of use the California timelines as examples, and the timelines in California are the same in every county. So if you're in the state of California, then what I'm going to talk about will apply to you. But if you are in other states, then you have to go out and find that information. And so I'm going to give you a little help at the end of where to go and find that. So let's take a regular motion hearing, right? Those have to be, when you go file a motion, you have to serve everything you have on the other side. You have to file it with the court and then serve it on the other side 16 court days before the hearing. So that doesn't include weekends. It doesn't include holidays. Now, when I say file and serve, that's the process in California. In some other jurisdictions, you have to serve it and then file, and then wait for the court to set the hearing. In California, as soon as we file it, they set the hearing date and then the other side gets to respond. In some jurisdictions, you have to send it to the other side. They get to respond. And then once the court has your filing and the other side's response, then they'll set a date. Okay, so I think they do that in order not to waste the court's time, because they want to make sure they have both sides' information before they set a hearing and take the judge's time. But again, there's still deadlines associated with that. In California, we actually prepare and file and serve the other side. And then once the other side's served, it invokes deadlines where they have to respond. Let's say I'm going to do this on example just so you can kind of get a feel for it. Let's say I go down and file something on March 1st, okay, of any given year. And the court gives it back to me and they might set a hearing for May 12th, right? Let's just say. And then I have to serve the other side 16 court days before May 12th. So I can serve it right then. I can sit on it. I can do whatever. Now, service, most people think of that as personal, like handing it to you. but it can also be by mail. Again, jurisdictions have different requirements depending on the circumstances. So you have to kind of figure out, do I have to serve this personally? Can it go by mail? And usually the court, the business office will be able to tell you those types of things. But then when that 16 days is there, you have to at least serve it on the other side by that day. And then they have to respond within 9 court days before the hearing. They have to file their response. Now, if you're serving it by mail, it adds extra time and all that kind of stuff. And I don't want to get into that level of nitty gritty because that's not really the point of this particular video. But the point is that whatever your timelines are, whether it's 16 court days before, whether you're the responder and it's 9 court days before, whether you're in another jurisdiction and it's got 10 days or 20 days or whatever it is, everything that you're going to present at the hearing has to go in by that deadline. That means your written declaration. That means your exhibits, your evidence, text messages, pictures, whatever it is that you want to present to the court have to go in then. Most of the time there's an initial filing and then there's a response to it. And then usually whoever filed that initial filing can come back and do what we call a reply. Okay, we have that in California. Some jurisdictions don't allow that, but in California we do. When that's the case, you have to have submitted all of your exhibits and everything, unless there's exhibits that are specific to that reply that you're giving new examples. But again, that reply has a deadline, right? It's like 5 court days before the hearing. So you have to be submitting stuff all along. You can't just hold it all back, walk into court the day of the hearing, and then hand over your stuff, because then the judge hasn't seen it, the other side hasn't seen it. And if you think about it really and you step back, the court reviews files in advance of the hearing. Like a judge has anywhere from, depending on where they're located and all that kind of stuff, they'll have anywhere from 10 to 30. I've seen them have up to 30 cases in a day. So they're not reviewing files, Johnny, on the spot. They're reviewing them the day or two before in preparation for those hearings. So that's why you have these deadlines of when you have to get everything in by, so that it makes it to the file and the court has it available to read and review and look at all your evidence, look at your declaration, and look at everything in advance of the hearing. Now, I will say that occasionally I have seen them with self-represented parties be flexible and sometimes take something because maybe you didn't know. And I've also seen them be flexible in sort of a domestic violence or protective order type situation. They're sometimes a little bit more flexible about it, but you can't really rely on that, because if the other side says, hey, that should be excluded because they can't submit that because they didn't do it in advance, they didn't send me a copy, I don't have it, then the court, can very easily say, I'm sorry, you missed your deadline, you can't submit it. Okay, so don't rely on, oh, I'm self-represented, I didn't know, and the court will give me flexibility. Try to get everything in, but if something has transpired in the meantime that you want to take with you, you can try it. It doesn't hurt to try it, obviously, but know that it's highly likely that it may not be allowed in. Okay, you have to know the deadlines and the procedures for your jurisdiction. And again, I see clients where they have attorneys, but like if I have an attorney and I have to respond 9 court days before, and I got the filing 16 court days before, let's say that my ex files something, he files it 16 days before, serves it on my attorney sends it to me and asks me for a response. I need to know that they have to submit it by that 9 court days before. So ask what the deadlines are. And here's the thing. If my attorney's filing deadline is 9 court days before, I cannot submit it to them 9 court days before. They cannot put it together that fast. I cannot exaggerate how tedious this stuff is and how much time it takes to put things together. I have a client I worked with on discovery the other night, and we did a call. We got on Zoom so that, we could see each other and I could help him work through the different questions and stuff. And then he's like, oh, I have, a week to get this done. And I'm like, I don't know that that's going to be a tough call. And he's like, I should be okay, blah, blah. And then when he started actually like pulling all the stuff and putting it all together, it's like, oh my gosh. And I'm like, yeah. And now your attorney has to go and like actually write out formal responses to every single one of these items and list every single document that you provided and all these things. Now, discovery in particular is tedious and it's another level. But I'm just saying that clients typically don't understand that if something has to go into the court 9 court days before, you have to get that to your attorney at least 11, 12 court days before, or they're not going to have enough time to put it all together and get it in for the filing. And they also have other cases going, so it's really important that you really understand and communicate with your attorney and say, hey, what's the deadline for filing this? When do you need, what's your drop dead date you need it from me by? What would you ideally, comfortably like to have it by? So that you understand all those pieces. And if you're self-represented, obviously that is very, very critical that you know those deadlines, okay? Let me just walk you through this. Every state has what we call a judicial council, okay? There's a judicial council of California, and there is a judicial council website that will give me all of the kind of high level rules, like the 16 court days and the 9 court days and all that kind of stuff. But it won't tell me local things, like there's very specific, like what size font your declaration has to be and the line number of the page where it has to start, or how the header's formatted and all these different things. And those things can vary a little bit between counties, or whatever that you're in. One of the things you want to do is the Judicial Council website is probably going to have the most information because obviously it's statewide and it's going to give you a lot of the high level stuff. Some states have forms for things. California is very form driven. Other states, not so much. You have to go to your local law library to pull out templates and different things. Sometimes you can find online law libraries in your state that have templates and things. But really, you go to your county court website and you want to look at, it's called local rules. Okay, the local rules are what's really going to set it all forth of all your different deadlines, when, how you submit evidence, how you submit exhibits. There's page limits, right? Like here we have page limits on how many pages that you can attach for your declaration and all those little kind of tedious rules. You want to go into your local rules and you want to go into the family law section specifically and read through those rules. Even if you don't understand everything that they say, if you read through, it will give you some general ideas of what you're dealing with. And then you can decide like, yep, I can dig in, I can learn this, I can handle this, or I can handle this, but I'm going to need a little support, a little coaching, a little help. Or you know what? I can't do this. I want to just hand this over to an attorney and have them do it. And again, even if you have an attorney, you having been sort of armed with that information will help you execute your case more efficiently with your attorney. You'll know all the deadlines. It's not uncommon for attorneys to maybe file a day late or whatever. Like we really try not to do that, but sometimes it's like pulling teeth to get it from the client and then you miss the deadline, which doesn't look great to the court. This is already such an uphill battle when you're going in front of the court that you want to do everything you can to make sure all your T's are crossed, all your I's are dotted, and you get all of this stuff in a timely manner. So if you'd like some support around this or learning more about these kinds of issues, you can go to divorceuniversityonline.com/VIP-coaching. There's information on that page. You can learn about my coaching programs, learn how I might be able to support you on this journey, and I will see you guys next time.
We'll grow in number, fueled by them to see the horizon, turn us to thousands.